This conference will now be recorded.
Okay, so the Tenant Fee Act 2019, Giles has asked me to cover purely on the fact that Giles is getting lots of questions regarding its implementation and how it works practically. As always, with all the legislation that I discuss on courses, this is relatively new in the sense that it came into effect on the 1st of June 2019. But obviously, a recent change made it applicable to all tenancies on the 1st of June 2020. So, as of the 11th of June, as of today, the tenant fee ban applies to all tenancies. So, I'm just going to go through the legislation, the basic summary of the legislation, and then just pull a few bits out where I think there may be some more benefit from going into it in a bit more detail. As I said, with all legislation, it's one of those situations where a lot of it comes down to interpretation. So my interpretation of the legislation may be slightly different to other people's interpretation, or maybe ARLA's, or maybe the NRLA, if that's what they're called now. So everyone will have slightly different interpretations. And I think the important thing to remember about the Tenant Fee Act is that the negatives of not complying with the Tenant Fee Act is imposed by the local council or Bristol City Council, who are the lead authority in relation to the Tenant Fees Act. So a lot of it will come down to how Nottingham City Council or maybe Derby City Council interpret the legislation if they were looking to pursue you as a letting agent or landlord. Now, I'm not, as a compliance person, I'm not going to sit there and say you should break the law, but I would certainly suggest, very similar to what we were discussing, or you may have heard me discuss on electrical safety, I don't think the local councils are going to be going out there trying to find landlords and letting agents who are non-compliant. What they will probably be doing is being quite reactive to complaints about landlords and letting agents who may have charged unfair fees. So I would assume they would probably ask you to return the money that you have charged, and they probably won't take any further action. Now, if you were a serial non-complier, then there is a very good chance that they would probably look to prosecute. So I'm going to assume, and I might be completely wrong on this, but I'm going to assume most councils will take a very practical perspective in relation to how they levy fines. They will probably be very educational in the first place. Look, Mr. Landlord, you shouldn't have charged this, or you shouldn't have charged this, Mrs. Landlord. Can you return it back to the tenant? And I think most of you, if you've made a genuine error, would do that. And I don't think the councils would take any further action. But if you were doing it on a repetitive basis, then there's a very good chance that's what they would do. So in reality, I think so long as you try and comply with the spirit of the law, and if you were slightly wrong, if you did slightly err in its interpretation, then I think so long as you remedied it without any further need for action from the local council, then I would be very surprised if they took any further action. The next slide I'm just going to put up is my housekeeping slide. So I'm just going to quickly go through that because, as I said, there will be a recording. If you've got any questions, don't hesitate to put them into the chat box, etc., etc. So that's just my housekeeping slide. Whoops, what's that popped up? So just in terms of dates, so it came in on the 1st of June last year for brand new tenancies, renewal tenancies, and any tenancy that went statutory periodic. So that date's gone, so don't overly worry about that date. The next date's the important one in relation to obviously this webinar. It now applies to all tenancies in existence. So prior to the 1st of June 2020, it only applied to some tenancies. It now applies to all tenancies that are in existence. So in very simplistic language, if you've got a clause in your tenancy which is asking the tenant to pay X, Y, and Z, and that is no longer allowed under the tenant fee ban, that is as if that is not written into the tenancy agreement, just to make you aware of it. So you don't have to draw up a new agreement, you don't have to do that, but that clause in the tenancy agreement which is asking the tenant to pay X, Y, or Z would be seen as if it was unwritten, if it wasn't in there, if it was written in invisible ink. So if you've got a tenancy that says the tenant must pay £100 for a checkout, then that clause is as if it hadn't been written there in the first place. So you don't have to amend your agreements. The law will already interpret or translate it as if it wasn't written there in the first place. There are certain fees restricted. So when we talk about the Tenant Fee Act, very logically, what they've done is said, look, all fees are banned, or all charges are banned apart from these. And we'll go through a slide. So that's the easy thing to remember. There's a whole list, not a whole list, but there's a list of fees that you can still charge. Anything else you aren't able to charge. And we'll go through that list very shortly, to also include how it affects the 1st of June 2020 tenancies. So in terms of the tenancy types, again, for those that have been on my basic law course may remember, so in terms of what we do as mainly as letting agents and landlords, the tenant fee ban only applies to assured short hold tenancies. So 99% of your tenancies will be assured short holds. And I don't know if anyone wants to type into the chat box what are the requirements for a tenancy to be an assured short hold for those that have been on my course, just to test your knowledge. So if I want to create an assured short hold, what are the tests of an assured short hold? What's the criteria, if anyone can remember? D-Line, I know you're on the course, so you've been on a few of my courses. Just
I would say it has to be your main place of residence.
Absolutely, it has to be your main or principal residence. For those that do student lets, students have a double life. They have a secret life. They're allowed 2 houses. They're allowed their term time house, and they're allowed also their parents' house. So students are given an assured short hold because the property they're renting for the university they're going to is deemed in law to be their main or principal residence. So that's one of the major ones. Also, it has to be a person. So if you do company lets, I don't think anyone's rented to a company, then that is not an assured short hold. That's what we refer to as a common law tenancy. So just be aware that a assured short hold or the Tenant Fee Act only applies to an assured short hold. So if you have a common law tenancy, or what some people refer to as a non-housing act tenancy, then you can still charge if you wanted to. I'm not saying that you would, but the Tenant Fee Act doesn't apply to you. So you've got a lot more flexibility in terms of what you do before the tenancy starts, during the tenancy, and at the end of the tenancy. So for example, you could have a clause in there saying if they were late with their rent and you had to send them a letter, you could charge them £30. Now, under a common law tenancy, you would be allowed to do that so long as it was stipulated in your agreement. However, under an assured short hold, you are no longer able to do that. So there is a difference in how different tenancy agreements are treated. So understanding the type of agreement you create is massively important, which is something which I always emphasize in my courses. So for those that may do on the odd occasion a non-housing act tenancy, then you are allowed to charge fees if you want to. I'm not saying that you have to. It's entirely up to you as a landlord, but you get a lot more flexibility in that sense. Is that okay on terms of the types of tenancies? But 99% of the agreements that you create will be an assured short hold, so they will be covered by the Tenant Fee Act. The next one is in terms of the persons. So the legislation is quite descriptive in who they say you can't charge. So you can't charge an applicant any fee that's not allowed under the Tenant Fee Act, and we'll go through the fees very shortly. You can't charge the tenant a fee which is not allowed under the Tenant Fee Act, and any other person acting on their behalf. So the most likely from a tenant perspective is probably a guarantor. So it's the applicant you can't charge, it's the tenant themselves that you can't charge, and equally as important, you can't charge a third person acting on their behalf, which could be, in theory, the local council, because some people might charge a local council an administration fee. So you're not able to charge that either. If they give you an incentive fee for taking on a tenant, or an incentive payment, that's slightly different. So if Nottingham, I don't know if anyone has had a payment from Nottingham City Council or any council where they encourage you to take on a referral from their homelessness department. So I'm based in Bournemouth, and our council pay £2,500 to take on a tenant from their homelessness referral unit. So that payment is outside of the Tenant Fee Act. So they're allowed to do that to reduce homelessness. So in most cases, it will apply to these particular people on the screen. So you can't charge the applicant, you can't charge the tenant, and you can't charge anyone acting on their behalf any fee which is not allowed under the Tenant Fee Act. And the next slide, I think it's the next slide, will include the fees that you are allowed to charge. Is that okay so far?
Daryl, can I just quickly ask you?
Of course.
I've just got one question here, so I'm just bringing it up. As I cannot charge fees for pets, can I charge a higher rent instead?
Yeah, that's a really interesting question, and one of those which we don't have a right or wrong answer. The situation was before the Tenant Fee Ban came into force. So ALA, which is the biggest professional body for letting agents, said, look, actually, we think you can charge a higher rent for pets. So, but you've got to advertise it in your, so to make sure that you comply with consumer protection obligations, you have to make sure that you advertise that in your advert. So you would say in your advert, pets welcome, the rent for non-pets is 700 and the rent for having a pet is 720. So that's what they said, that's what ALA said you should do if you wanted to advertise a property with a pet. Now, my argument, because I actually disagree with that. Now, the reason why I disagree with that is the legislation doesn't allow you to charge extra for a pet. It's not said that. So that's a situation I believe you've got in the fact that I don't believe that the legislation allows you to charge different rents or advertise it as different rents in relation to a pet. So I would say if you want to agree a higher rent for a pet, then you don't advertise it. You just advertise the property at 800 or 850, whatever it's going to be. And if you negotiate a higher price with a pet, then the tenancy agreement just reflects the rent level and not whether or not you're accepting a pet, if that makes any sense. Now, my concern about having different or advertising the property with different rent levels for pets is that at the end of the tenancy, if there's any damage to a property, what is that tenant going to say to you? So you're charging them an extra £40 a month for having a pet. So at the end of the tenancy, and there's £1,000 worth of damage caused by the pet, what is that tenant going to say to you? What do you think, Adila? If you're still there.
I'm still there, but I was working. So I missed that one.
I don't know things about it. So my position would be is that if you advertise a price and you negotiate a higher rent for a pet, that's fine, but don't put anything into the tenancy agreement about you having charged an extra £30 for a pet, which is what ALA are saying you should do. Again, I don't know what the NRLA are saying. That's the new name for the National Landlords Association and the Residential Landlords Association, but I would disagree with that. I would never advertise my property at two different rent levels. I would just have one rent level. If they come to you and say, look, I want to have a pet or a dog, you can't take a pet fee, you can't take a higher pet deposit, you can't do that. I would just negotiate a higher rent level, but there would be no mention within my tenancy agreement that was on condition of the pet being taken, if that makes sense. Because I believe at the end of the tenancy that they just go to you, well, because you if it's advertised at a higher rent level because of a pet, then they're just going to say any damage is being taken up by the extra rent that I'm paying. So in that sense, it's one of those real ambiguous issues, but I would certainly not advertise it at two rent levels, if that makes sense, Adila.
Yeah, that's great. I've got one more question. Shall I wait till later on? Or do you want
Let's crack on with this. Let's crack on with this
Okay.
slide, Adila. So,
Fine.
in terms of rents, you can absolutely charge rent. So, all landlords will be glad to hear that. You can charge whatever rent you wish. So that's an agreement between you and the tenant. There is at the moment no restriction at the moment on what rent you can charge. So long as the tenant agrees to pay that rent, that's entirely up to them and you. The only thing that you can't do is have a higher rent in one period of the tenancy than another. So what the government were concerned about was all landlords and letting agents would increase the rent for the first month to cover the loss or the cost that they would incur from doing the inventory and referencing checks, etc. So, for example, you would charge 800 for the first month, and then you would charge 700 for the following months. because the first month is extra because you wanted to cover your costs in relation to renting out that property. The government said that you can't do that. So you can't have a higher rent in the first or second month than any other month in that tenancy. What it doesn't stop you from doing is equating the costs of your initial renting costs across the whole of the 6 months. So if you just added an extra £50 for each of the 6 months, that doesn't stop you from doing that. You just can't have a fluctuation in the rent, if that makes any sense. So the first, second, or third month can't be higher than the fourth, fifth, and sixth month. So the legislation doesn't allow that. But in terms of the rent itself, you can decide whatever rent is agreeable between both parties. It just can't fluctuate as described. The other one that you're allowed to charge is a deposit, a tenancy deposit, and that depends on the level of rent that you're charging per annum. So just be aware the calculation is written into the legislation. It's the monthly rent times 12 divided by 52. So that's what the legislation actually says. So it's the monthly rent times 12 divided by 52. You get the weekly rent, and then you times it by 5 or by 6, depending on the screen whether or not the rent is below or above 50,000 per annum. I'm going to assume most of your rents are below 50,000, so in that sense you would only charge a maximum of 5 weeks. Okay. The thing that's popped up, and I think a question that happens a lot, I don't know how many of you are holding deposits of more than 5 weeks. Now, the legislation was reasonably silent on what happens to current tenancies, as in tenancies that started before, or when you took the deposit before the 1st of June 2019, and you never renewed that tenancy. What would you do with that deposit on the 1st of June 2020? Now, lots of people are saying that you don't have to refund the difference between what you've taken and the 5 weeks if you had taken more than 5 weeks. I personally, to remove any risk whatsoever, even if it's 10 pence, I would return that extra 10 pence to the tenant. So if you're holding 5 weeks and 2 days extra deposit, or 2 days extra deposit, I would return those 2 days back to the tenant to make sure you fit below the 5 weeks. Because the last thing you want to do is serve a Section 21, go to court, and shelter or CAB or legal aid or the judge or him or herself sits there and says, actually, you've taken more, you're holding more than 5 weeks deposit. Then you've got to sit there and argue what the legislation says. So for the sake of a couple of days worth of deposit, I would just return that excess deposit amount. And when I've done that, I would make sure that I reserve my prescribed information in relation to deposit legislation to 100% protect myself. Now, legally, I don't think you have to, because you're not receiving any more deposit. You're actually returning the deposit. But from a risk scenario, again, why would you want to risk your Section 21 being thrown out? So I would just absolutely return that money to them, reserve the prescribed information and a scheme leaflet for whatever scheme you're using, whether it's the DPS, the TDS, or my deposits. That's what I would absolutely do. So that's probably one of the most common questions that I've received. And I think that's a question you've received a lot, Giles, from the questions that you've been asking me. So that's something I would absolutely do.
Yeah, absolutely. It certainly has been. It's a consistent question that keeps coming up week after week.
Yeah, and as I said, a lot of the bodies are saying out there. So all the deposit schemes, I think the NRLA are saying it. They're all saying that you don't have to return that extra money. That's fine, not a problem at all if you want to follow that route. But if it goes wrong, they're not going to recompense you for the thousands of pounds that you spent going through court. So for the sake of 2 days worth of money or even 10 pence, I would just return it. Then you're never going to have a problem because you're always going to be below those 5 weeks. Now, in terms of how you calculate the 5 weeks, is at the point of that tenancy. So if the rent's increased since you first took the deposit, it's the current rent level, which is the rent level you use to calculate your deposit. Because obviously there may have been an increase of rent from when you first took, or increase in rent level from when you first took the deposit. So it's calculated on the current rent that you're charging. So if you're charging more rent than you were when you first took the deposit, it might be below 5 weeks, obviously. So you need to calculate them out. But I would certainly go through all your agreements and make sure that you are holding 5 weeks or less, just to protect yourself. Also, the importance of doing inventories can't be understated. So many landlords don't have robust inventories in place. It's just something which a lot of landlords don't do. Again, you cannot, or you'll have you'll have a very poor chance of being able to deduct from a deposit if you do not have a very detailed inventory when they first move in and a very detailed inventory when they move out. It's very unlikely that you'll be able to deduct from a deposit, because most of the adjudication schemes or the deposit schemes will not adjudicate unless you have a check-in and you have a check-out. So that's really important as well. You can still deduct rent, that's fine, because rent is not based on an inventory or a checkout. That's fine, you can still deduct rent arrears, but you will be very unlikely to be able to deduct from a tenancy deposit unless you have a very detailed inventory and a checkout. What else are you allowed to take? A holding deposit. So I don't know how many of you landlords take a holding deposit. Personally, I wouldn't take them. There's a whole raft of legislation, which a whole raft of procedures that you have to follow when you take a holding deposit. So that could almost be another webinar on its own. You've got to get them to sign a copy. You've got to get them to see a copy of your tenancy. You've got to get them to sign a holding deposit form to say they understand why you're taking the deposit, under what circumstances you can deduct, etc., etc., etc. So I think, sorry, Dean, about putting you on the spot. Do you have a copy of my holding deposit form? I think I did give it to you for your members. So if you are taking holder deposits, which I know some of you may do, then as a landlord, you need to make sure that you get them to fill out one of my holding deposit forms or one of the MPO's holding deposit forms. Because if you don't do that and you don't show them a copy of a specimen tenancy agreement, then you'll never be able to deduct from the holding deposit. Sorry, dealer.
No, it's okay. Sorry, I do believe we do have the holding deposit form. I was just trying to locate it.
That's fine. So if you do need one and you do utilize holding deposit forms, then I would just encourage you to get a copy off a dealer. But equally as important, in addition to the holding form, you've got to give them a copy of the specimen tenancy. Because if you don't give that to them as well, then they can just pull out saying, actually, I pulled out because I didn't know what I was contracting into, which is fair logic. So holding deposit form, they sign it to say they understand the reasons as why you're taking the holding deposit, and then also a copy of the specimen tenancy agreement as well. But again, for me, just from my own perspective, I personally wouldn't deal with holding deposits. I think it's a lot of hassle, a lot of work for the sake of 1 week, which in most cases you may not be able to deduct from. But I fully accept you may want to get people to buy into a property. So I'll leave that to you in terms of how you feel you want to move forward. But it's not something I personally would do myself. Other fees you're allowed to charge. So these are more in tenancy fees. So we've got the rent and deposit and holding deposit, which are before the tenancy sort of starts, so to speak. Then we've got what I'm going to refer to as the in tenancy fees. So this is what the Tenant Fee Act allows. A lot of it comes down to interpretation. So again, we don't have any court cases about interpretation yet. I expect there will be at some stage court decisions about what we mean by certain elements of the Tenant Fees Act, and I think they will probably be around these types of issues. So a change of a clause. So if you've got to amend the tenancy in any way, then you can charge the tenant up to £50 inclusive of VAT. It's got to be reasonable, okay, just to make you aware of that. So if you're allowing them to have a friend stay or a permitted occupier, how much time is that going to cost you in terms of doing that? Not a lot. So I'm not too sure if you'll be able to charge much more than maybe £10 or £20. But the legislation says a reasonable amount up to a maximum of £50 inclusive of VAT. So again, if anyone questions it, you've got to be able to justify that fee. I'm assuming most landlords probably wouldn't charge a fee, but if you did, then you've got to be able to justify it. And that's what it comes down to. What is reasonable to you may not be reasonable to someone else. The same applies to lost keys. a reasonable charge for them losing their keys. So if they come to you and say, look, I can't get into the property, I've lost all my sets of keys, then obviously what is a reasonable charge? And the reasonable charge would be whatever your locksmith will charge you, I would assume, and maybe a little bit extra for your time. So again, we don't have an absolute interpretation of that. Again, it's all about reasonability. Can you justify the fee that you are charging that set of tenants? And that's what it's about. Are you being reasonable? So I'll leave that to your own devices and what you believe is reasonable or not is what isn't.
Daryl,
Surrender.
sorry, Daryl, can I just quickly ask, if you're a landlord and you're working and you have to stop your work to go and get a key cut to give it to your tenant, surely the amounts would vary quite a lot just depending on how, you know, how much time you've had to take out.
Well, if it was you, a dealer, it'd probably be about £1 million an hour or something, wouldn't it? From my understanding.
As you know.
Yeah, I mean, I don't think they take into account second jobs. So I think they worked out when they did the research into the Tenant Fee Act, they looked at what a letting agent would be able to charge. Or they say as letting agents, they looked at letting agents. They think the hourly rate of a letting agent is about £13 to £14 per hour. That's what they looked at to give you an understanding. So if it took 3 hours of your time, I think you would be talking around about £40. That would be a reasonable estimation based on what the government said a letting agent should earn, or what the costs are of having a letting agent. So that's what I would base all my assumptions on government research, because in the end, then you can't be deemed to be unreasonable. You're doing something which the government have researched themselves. So that's what I would probably base my my charges on, which obviously would be nowhere near what you get paid a dealer. So sadly, you might lose out on that one. So surrender. So a tenant's come to end the fixed term. So I've got a 12-month fixed term. There's two of us. We both want to leave because our circumstances have changed, or I've lost my job, or whatever it's going to be. If I come to you and say, look, Mr. Landlord or Mrs. Landlord, I want to leave early, then you can charge a fee. Now, there is no limit to what you can charge. It only says about reasonable. So if you're using a letting agent, for example, and that letting agent says to you, okay, we're happy to remarket the property, but it's going to cost you £600, Mr. Landlord, that is a reasonable fee, because that's a fee that you would incur as a landlord. So long as you can justify your fees, then you are allowed to charge as much or as little as you want when you're dealing with surrender. And surrender is about when a tenant wants to end a tenancy earlier than they've agreed. So just be wary of that. So as I said, the fee, there is no cap to what you can charge. The legislation just says the word reasonable. So long as you can justify. So if you had to do a checkout, if you had to pay a letting agent to remarket the property, if you had to pay for someone to do a check-in, whatever it's going to be, all those costs are reasonable in relation to you agreeing to that surrender. So the tenant can agree or disagree. They can, if they don't want to pay those fees, you can say, well, fine, I'll let the tenancy continue for the rest of the fixed term. So that then it's down to the tenant to decide what they want to do in relation to agreeing to those fees. So surrender, there's a lot more flexibility. The landlord is in a lot more control in relation to that whole situation. So you can charge as much or as little as you want, so long as you can justify those fees. The next one you can charge, late interest on arrears 14 days after they become due. So if the rent was due today, being the 11th of June, I could start charging late rent interest from the 25th of June. And that is capped to 3% above Bank of England base rate. So what's it at the moment? Is it 0.25? So you could charge 3.25% on any rent that's due, so long as it's 14 days overdue. But then you can backdate it to day one, if that makes any sense. So it's got to be at least 14 days overdue. When it's 14 days overdue, you can then start charging interest rate on those arrears, but you can backdate it to day one. Now, the mathematician in me says actually it will probably cost you more to work out the interest than you will actually receive. It's something like 26p a day or something ridiculous like that. So most people don't charge it, but if you wanted to charge it, you can certainly do that. But I would probably say most of you won't. But if you wanted to, then the Tenant Fee Act allows you to do that. And the last one, which you're allowed to charge, it hasn't changed one zip. The Tenant Fee Act hasn't changed this at all. You can still make deposit deductions. So if they owe you rent, if they've damaged the property, if they've returned it unclean, whatever it's going to be, you can still deduct from the deposit, and that has not changed under the Tenant Fee Act. So you're allowed to make those deductions as per normal.
I thank God for COVID-19. I thank God for COVID-19 because it's giving parents opportunity to study their children, to observe their children, to see.
I'm not too sure who that was. That certainly wasn't my TV, just to make you aware of that. I'm not too sure where that was coming from. Maybe we've been hacked into. Maybe that's one of those. I think Zoom was being hacked into by someone, but certainly not me. It's not coming from my end anyway, so apologies for that interruption. So that's in terms of the last two slides were in relation to the fees that were allowed to be charged. Okay. Any questions on those, Adina?
Yeah, hi. Right, I've got a few questions. So the first one is, hold on a sec. I charged the tenant a renewal tenancy fee before June the 1st, and it hasn't been paid yet. Can I still demand this fee from the tenant?
Yes, because it was chargeable before the 1st of it. You know, it was when you receive it, it's like, but the obligation to pay it was before the tenant fee ban came into force. If that makes any sense.
Yeah. Can I still charge rent? Oh, sorry.
Sorry, just to go back on that. So long as it was the actual renewal happened before the tenant fee ban came into force for that tenancy, if that makes any sense. So you can charge. So if you had a renewal fee in your tenancy agreement, which you created in 2018, and the renewal happened in 2019, you can charge it, but you can't obviously charge it in 2020.
Yeah.
Or after the tenant fee ban come into force.
Okay, great. Next one, can I still charge rent with all bills inclusive?
Absolutely, yeah, absolutely. It allows that, yeah.
Right, next question is, with student tenants, can I divide the annual rent by 4 quarterly payments? And because students only receive 3 student loans, allow them to pay a smaller amount in July when they move in, bigger amounts in September and Jan, and in April, a smaller amount?
So long as the quarterly amounts have been calculated, so long as the daily rate is exactly the same, then fine, absolutely. So how you calculated the daily rate must be exactly the same for the 4 quarters. So what you charge in July, when you say a smaller amount, it's only a small amount because there's only 1 month, but how you calculate July must be done on the same daily rate basis as you've calculated for autumn, winter, or the spring term. If that makes sense, Adina.
Yeah, that does. That's fine. Somebody's asked, yeah, that's fine. Sorry. Somebody's asked, is there a readily available late interest calculator? But then someone else has actually sent me the link for this calculator. So what I'll do is I'll email it to them. So it's
yeah, as I said, from my own opinion, I think it will take you longer to work out the interest payable. It'll probably cost you more in terms of sending a stamp than it will be in the interest that you're going to get. But I'll leave that to your own discretion. Obviously, if it's a large amount over a long period of time, then it will mount up. But from my experience, it won't be more than a couple of pounds generally, unless it was for a long period of time. Is that okay, Adina?
Yep, that's great. There's no other questions at the moment. Has anybody got any other questions?
I'll mute you. I'll move on because I know we're shortest of time. Okay, so during the tenancy itself, which is my next slide, there are only what I'm going to refer to as permitted fees. So the one that comes up quite a lot are the next 2 slides, next 2 points. So if I have a tenant who's caused damage, or if I have a tenant who's caused me to get a contractor out. So if they've blocked the toilet, for example, with their waste, nappies and wet wipes and all those things, then sadly, I cannot charge or recoup at the time the cost of my contractor going out to do that work. Even though I think it's been caused by the tenant, I will not be able to charge it at the time. Now, if they make the payment themselves, that's entirely up to them. But I can't go to them and say, by the way, my contractor just charged you 150 quid to unblock that toilet, and that toilet was blocked with all your waste. because that's not a fee allowed under the tenant fee ban. What you can do is you can, at a later stage, deduct it from the deposit. So there's no problem there. So you just can't charge during the tenancy any fee which is not allowed under the Tenant Fee Act. You are allowed to deduct it from the deposit because it's a breach of the tenancy, but you can't charge it during the tenancy itself, which I know is slightly confusing, but that's how the legislation is written. So just be wary of that. Even if it's the tenant's fault and the tenant admits to it, the cost of that contractor, you can't request it direct from the tenant because they have that's not allowed under the tenant fee ban. If they pay it themselves, slightly different matter. If they go to here, well, here's 100 quid for it, I've got no issues with that. But at the end of the tenancy, you are able to deduct from the deposit because they have breached the terms of the tenancy. So if you look at the EMPO agreement, for example, you will see when I changed it last year, I've removed all the references to the words pay, apart from the fees that are allowed. So, for example, I put there pay for call outs which aren't necessary. So I've removed that. What I've said is that the tenant can't block the toilet with their waste. So if they've done that, and I can prove that they've done that, then I'm able to deduct it from the tenancy deposit. I can't charge them during the tenancy, but I can charge them from the deposit, or I can deduct it from the deposit. But as you see on my slide, you need to have evidence. So if they admit to blocking the toilet, get them to write you an email or to confirm it as an email. If the contractor says it's been blocked with their waste, get your contractor to send you a statement to say that's the case. Because then if it does go to adjudication at the end of the tenancy, you'll have evidence, which I always say, in relation to what you believe has happened and whether or not you're allowed to deduct from the deposit. So just be wary of that, because that's something which lots of landlords and lessee agents have sort of misunderstood. They still feel they can charge for costs incurred during the tenancy itself, which you are not allowed to do so, sadly. And there is a risk to that, because obviously if they complain to the local council, there's a very good chance the local council will say to you, by the way, you charged a fee that you weren't allowed to charge, so therefore you've got to hand that money back to the tenant, which you would be obligated to do. And if you didn't do that, then there's a very good likelihood that the local council would probably then start fining you and saying, actually, you're not complying with the terms of the Tenant Fee Act, so therefore we're going to look to fine you for being non-compliant. Next slide is my deposit one, which I sort of referred to earlier. So you can still deduct from the deposit, no problem at all. I'm going to keep referring to making sure that you've got a very detailed check-in when they first move in and a very detailed checkout. You can still charge for cleaning at the end of the tenancy if the property has not been returned to you in the same condition as when you first gave it. You can't force them to have it professionally cleaned, and that particular clause has been unfair since day dot. So the Tenant Fee Act has not impacted on that, but in a sense, it's sort of encouraged people to remove that clause. So I've always had a problem with you must get the property professionally cleaned before you hand it back to them. There's no legal obligation to do that, and there never has been. They've only got to return it in the same condition, less fair wear and tear. How they achieve that as a tenant is entirely up to them. You can't force them to use ABC cleaners. That's not your decision. Ultimately, if they return it to you in a poorer condition than you gave it to them, then so long as you can prove that, then you do have the ability to deduct it from the deposit if the adjudication schemes allow that to happen. So you've got to go through that process, but you're allowed to deduct cleaning from the deposit so long as it's been returned to you in a lesser condition than when you first gave it. So damages, all those things are still allowed to be deducted from the tenancy itself. The next slide is just confirming in terms of what happened or what were the obligations of the 1st of June. As I discussed earlier, if you have excess deposit, in my own opinion, I would return that excess deposit back to the tenant, irrespective of when that tenancy started, irrespective of how many times you've renewed that tenancy. I would just return and refund that excess amount and make sure I also reserve prescribed information. I would also refund any fees that you may have taken in advance. So one of the most common ones would be maybe a checkout fee. So they moved into the property in 2018 before the tenant fee took effect, but they're moving out in 2021. The actual fee, that fee was incurred not in 2018. That fee was actually incurred in 2021 when they physically moved out. Even though you took the money earlier, the argument there is that actually the fee itself, in terms of the checkout fee, won't be incurred until they physically move out, even though you may have taken that fee earlier. Now, in most cases, most landlords wouldn't do that, but it was very common with letting agents. They were taking checkout fees up front before the tenant moved in, so they obviously had that money and they didn't have to ask it from them when they physically moved out some years later. So if anyone's holding any checkout money, then I would say that you would have to refund that money back to the tenant to comply with the Tenant Fee Act. And any clauses that I said earlier are unenforceable. So any clause that you have in your tenancy that says the tenant must pay X or pay Y, and that payment is not allowed under the Tenant Fee Act, it is as if it has been written in invisible ink. So it's basically been crossed out. So all of those, your tenancy agreement is still 100% valid in the sense of its enforceability, but those clauses have been basically struck out by the legislation itself. So just be aware of that. And as I was saying earlier, the risk of taking or holding fees that you shouldn't have taken actually is a lot lower than probably people think in a sort of legislative sense. The risk is, I would say, a lot lower than other forms of legislation, because ultimately, so long as you give it back to the tenant, then you can serve a Section 21, which you'll see on the next slide. And from my own opinion, I think most councils will take a very light touch approach to penalties. So long as you're not a serial offender, then it's very likely they will just say, look, can you return that money back to the tenant because we believe that's an unfair fee, and do it within the next 7 days. So long as you do it, I'll be very surprised if any council starts to issue penalties. As I said, I think they will reserve them for the more serial offenders in our midst. And then the last slide just covers the penalties, which I've sort of referred to throughout the whole of the webinar, and that is you can't serve a Section 21 at all until you refund the money. So it doesn't stop you from serving a Section 21. You still have the ability, if you've taken an unfair fee, you can return it, and then you can serve a Section 21. So the penalty there is not that severe. So long as you refund the money, then you will be able to serve a Section 21. Probably the biggest danger is if trade and standards get involved. So Bristol City Council are the lead council. You obviously have Nottingham City Council in your local area, and they can levy a fine anywhere from £1 up to 30,000, depending on the severity of what you have or you haven't been doing. So I've not seen any fines as of yet. So I think most councils have taken a proactive, a light touch approach to non-compliance, which I think is the fairest and easiest way of doing it. And you'll be glad to hear at 10 to 1, I finished my set of slides. I don't know if a dealer or Giles want to interact at this point in relation to questions or comments, etc. Or if anyone has any questions, they're more than welcome to unmute themselves or type into the chat box.
There's a couple of questions, Daryl. The first one is, what charges can be levied if tenant wants to leave before the AST end date, if the landlord doesn't agree to end the contract? Is the tenant legally liable for rent to the end of the tenancy? Can't hear you, Daryl.
Sorry. The Tenant Fee Act doesn't stop that. So if the landlord wants to charge rent until the end of the agreed period, they're more than welcome to do so. If the tenant leaves early, that's entirely up to them, but they're still contractually obligated to pay whatever the rent is within the tenancy. So I think most good landlords will agree a surrender and probably not charge too much, only the cost that they would incur in relation to remarketing the property.
Daryl, just on that, do you have to have an official surrender document from, you can't just make one up yourself?
You can make. I mean, there is no obligation, as most people will know. There's no obligation in law to have anything in writing in relation to into tenancy agreements. I could just agree with you to rent the property out for 6 months on Lenton Boulevard. It makes no difference. Obviously, from a landlord perspective, it makes it very difficult for me to be able to prove what's been agreed between parties. So a surrender document could be as simple as a one-liner if you wanted to, but obviously it's going to be a bit more detailed than that. It will probably detail what the tenant's expected to do, what they need to do with keys, cleaning, utilities, what's going to happen with the deposit. So the document can be on one side of A4, no problem at all. It doesn't need to be done in any particular way.
Daryl, there's one more question here. How would you suggest getting, so as an example, how would you suggest getting £500 back for breaking a shower when the deposit was, say, only £200?
Take a larger deposit. There's no easy answer to that one, I'm afraid. If they won't pay the £500, which they probably won't, obviously your deposit won't cover it. So you're going to have to either chase the guarantor if there's a guarantor, or take them through small claims, which obviously we know is a bit pointless for only £300. So sadly there, Angela, it's not an easy question, I'm afraid. Although to be fair, I don't think really the Tenant Fee Act has made much difference to that. They probably wouldn't have paid it anyway, irrespective of the Tenant Fee Act. Anything else, Adila?
No, Daryl, that's it.
I've just got a quick one, please. Just going back to the fully inclusive rents with bills. What happens if the bills are estimated at the commencement of the tenancy, and you get to a situation at the end of the tenancy where the bills have actually been less than what the landlord has collected in terms of the monies for the bills? What happens to that? What happens to those monies? And by the fact the landlord's collected an additional amount, does that put him at peril?
Not at all. If you just say the rent's £800 a month, Giles, and that includes his bills, it makes no difference about what those bills are. So if the bills come in a lot less than the landlord anticipated, the Tenant Fee Act or any legislation has no effect upon that whatsoever. If you were charging it separately, then there's a slightly different matter. So if you were saying the rent's £800 a month, and then I charge £10 or £20 per week for the electric, that's a different matter. That's hence why I would always include it within the rent. So all I say is the rent is inclusive of electric, gas, water, whatever it's going to be. It's when you separate them out, that's when you have a problem.
Okay, thank you.
Was that it, Giles? Hopefully everyone's found it useful. Is there any other questions? Hopefully I can't see any others on my screen unless I've missed them. But as there will be a recording made available, and I will send it to Giles and Adila for them to distribute it to the membership. If you've got any questions, as I always say, don't hesitate to contact Giles and Adila, and I'm sure they will contact me in return. But otherwise, I will leave you all in peace, and I will wish you a good day. And hopefully we'll speak to you all soon. Thank you.
Thank you, Daryl. Appreciate it.
Thank you.
Thanks,
Thank you,
Daryl.
Darryl.